All right, so I think we're going to get started here. Again, my name is Jen Torgerson. I am a sales counselor here at Riverwoods Manchester, and I'd like to welcome everyone to the program today. A few reminders, please, if you would. You are on mute, so we can't hear you, we can't see you. However, we do welcome your questions. You can type any questions into the Q&A box at the bottom or the top of your screen. We ask that you please respectfully keep questions and comments kind in nature. Your suggestions on future topics are welcome, as well as ways in which we can improve our programs for the future. So we certainly appreciate that. So feel free to start your typing any questions into the Q&A box at any time, and we will get to those questions at the end of the presentation. So Riverwoods was a grassroots organization started by two women, Mariana Hatch and Rosemary Coffin, over 30 years ago, and they helped fundraise and helped create the first Riverwoods community in Exeter, New Hampshire, which was called The Woods. This was so successful that Riverwoods then decided to build the Ridge and then the Boulders after that. So the Riverwoods Exeter community includes 3 campuses, and just a wonderful, wonderful environment and place to live and work. Riverwoods Manchester came about when Riverwoods affiliated with what was then known as Birch Hill, had a great reputation in the Manchester area for many, many years, since the early 90s, and Riverwoods affiliated, and then this became a Riverwoods community. And now, after a $30 million renovation inside and out, we are building 18 new cottages, and it's just been a tremendous success. Riverwoods Durham opened in 2019, our newest community. It's located about 2 miles from the University of New Hampshire and about 10 miles from Portsmouth and the seacoast. And it's just a great location. Each campus is unique, separate financially, wonderful environments. And as I said, residents love living in these communities. The staff love working here. And it's just a great plan. So what are we all about? Riverwoods is a CCRC, or a continuing care retirement community. So it's really a plan for the future that requires that you move in when you're independent. We are an insurance product. Our contract is reviewed by the state of New Hampshire and the Department of Insurance annually, and our financial performance is submitted to the state annually as well. Essentially, you are prepaying and ensuring future care. So assisted living, memory support, or nursing needs in the future if you need it. And because of this, a portion of the entrance fee and the monthly fee are tax deductible, or may be tax deductible if that applies to your situation. But it's also a lifestyle choice. People move in, life gets bigger as you age, and there's more available to you. People tend to get more active. It is independent living, so you can be as active as you wish to be. But in general, it's more socialization, more activity with lots of relationship and support of a community. So community support with a care coordination team available that meets every week if anyone has any issues at all, and is available to get you the care you need and help coordinate with your physician and your family and when that happens. So it's a wonderful environment with this whole community support system in place. And it allows you to stay in control of your life, know where you will receive future care, what the cost of that care would be, who's providing that care for you, and that you'll have care available when you need it. So it allows you to stay in control of your life, and it's a way of preserving assets for your estate while having this wonderful lifestyle available to you. So now I would like to welcome and introduce Andrea Daly. Andrea is a partner at Robinson, Besch, Sennett, and Daly in Portsmouth, New Hampshire. She's licensed since 1997. Her practice focuses on risk management and licensing defense matters for a broad range of licensed professionals. Andrea has successfully defended many psychotherapists, physicians, nurses, and dentists who are the subject of complaints filed with licensing boards. She is also has expertise handling a broad range of probate and fiduciary actions, including guardianship proceedings, will and trust challenges, and fiduciary duty matters. Andrea is licensed in New Hampshire, Massachusetts, and Maine. So Andrea, welcome. Thank you so much for your expertise today, for joining us. We will go to questions at the end of the presentation. And again, we suggest people type any questions into the Q&A box at the bottom or the top of your screen, and we'll get to those toward the end of the presentation. So I'm going to hand it over to you.
Okay, that's great. Thank you very much for having me. You can all tell my picture on the screen there was my pre-COVID picture, right, with my dark hair, but it's nice to be here. I am going to try to provide you all with a large amount of information. I look forward to hearing questions based upon the presentation. I'm going to try to make, this is going to be kind of like a 30,000 foot overview of a lot of complex issues. Even though my bio started by talking about my licensing defense work, a large majority of what I do is litigate on probate litigation matters, which means essentially my partners do estate planning. I get involved as the litigator when the planning doesn't go the way that folks intended it to go, or there's a dispute among family members about how a matter, either an estate or a trust, is being administered, or if there's some sort of challenge about the validity of documents. I also do a lot of guardianships, which are very common when people didn't get power of attorney documents in place. So a big part of what my hope here is by explaining why estate planning is so important and getting people to think about the things that matter within the big picture of estate planning, that I can also provide you with guidance as to essentially how can you prevent your family members from having to hire me. It is sad to me when money that you all have worked hard to save and money that you want to be able to pass on to generations or to other loved ones ends up being used to litigate matters. To me, even though I benefit financially from it, nobody else seems to benefit. And so if I can give some feedback as to how to prevent those things from happening, then we'll have accomplished something here today. So I think that it's also important for me to just tell you that, every situation with regard to estate planning and probate litigation is different, and these situations are all very fact specific. So I'm happy to answer broad questions, but do keep in mind that, I don't know who's here on the screen, and I'm not representing you, and I'm therefore not providing legal advice since we don't have an attorney-client relationship. It's really important that you take the information you learned today and then go schedule an appointment with an estate planning attorney in order to get specific advice to your circumstances. If there are folks on this call who want the name of an estate planning attorney, I'm happy to provide some recommendations, starting right with my partners here in the office. And there are a lot of other good folks throughout the state if people are looking for recommendations. So my hope is that we can start by just talking about what kind of documents everybody needs. In a perfect world, what kind of documents would I tell you that you should all have? Well, in a perfect world, I would tell you that you should have a trust, a revocable trust. You should have a will, and in a perfect world, you would have a will that is called what's called a pour-over will, which essentially means that any assets that didn't get named into your trust or titled into your trust before your death would essentially pour over into your trust upon your death. And then the other essential document is really two different documents, but they're the same type of document, and that is power of attorney. Everyone should have a power of attorney for healthcare. In some states, it's called an advance directive. There are other names for it, but essentially it's a document that allows somebody to make healthcare decisions for you if you become incapacitated. And that could be temporarily incapacitated because you had surgery and things went wrong and you're unconscious for an extended period of time, or it could mean that you have dementia. So anywhere from being fully capacitated to being deceased, there's a big window where someone might need to make decisions for you about healthcare. And then there's what's known as, generally speaking, as a durable general power of attorney. And that's the same type of document, but to handle financial matters. Everyone, in my opinion, who's over 18 years old should have those two documents. My son, who recently, turned 21, one of the first things we did when he was about 19 was get power of attorney documents executed so that if anything happened to him, he would be in a position where we could assist him. So are you going to be in a difficult situation if you only have a will? Or if you only have a will and power of attorney documents? No, you're not going to be in a bad situation. It's really a matter of choice. What I'm hoping everyone gets from this is that if you don't have an estate planning document, if you don't have a will or a trust, I hope what you walk away from here today is an understanding of how important it is for you to have one of those two documents, if not both. The primary difference, and I'm going to explain these in a lot of detail, but the primary difference between a will and a trust is that a will is going to be basically handled through a legal process, and therefore a judge and a court are overseeing what is happening with regard to what your will says and what kind of assets you have. Whereas a trust is administered outside of the probate court process unless there is subsequently some sort of litigation. So the most important thing to understand at this point is that if you have a valid estate plan, it provides clarity to your loved ones about what you want done when you pass away, and it helps ensure that your wishes are carried out. If you don't have a plan in place that is valid, then a court and a judge are going to decide how your assets will be distributed. And it's based upon a statutory scheme. Fairness doesn't enter into it, expectations, promises, hopes of loved ones, none of that ends up really mattering. And it unfortunately leaves a lot of families feeling like things didn't happen the way that they had hoped or expected. And I would like to make sure that you all avoid that process for your loved ones. Okay, so let's talk about trusts and wills in more detail. So a trust is, they're all different kinds of trusts. The two big kinds are revocable and irrevocable. Within the world of trust, there are many different kinds of trusts, particularly for people with excessive assets who are looking to do tax planning. Then you're going to want to go to an estate planner and really talk about the different kinds of trusts that you can have. But for the purposes of this conversation, it's really important to just understand the difference between revocable and irrevocable. An irrevocable trust is essentially a trust that cannot be changed without jumping through a bunch of hoops, one of which is going to court to get approval or to get everybody who is a beneficiary under the document to sign something agreeing to the change. There are many people who have in years past, for the last couple of decades, have done something called Medicaid planning, where they've done an irrevocable trust and basically put somebody else in charge of their assets with the hope of avoiding avoiding it, like looking like they're your assets. And the idea is that you could do Medicaid planning and therefore become eligible for Medicaid. I'm here to tell you, in the state of New Hampshire, that does not work. Those are still your assets. And it's really hard because of all sorts of things like a 5-year look back period to try to do that. So I would encourage everyone here, unless you're getting very specific legal advice otherwise, if you do have a trust or you're considering a trust, to do a revocable trust so that changes can be made during your lifetime. And if you have a trust, the trustee of your trust, oftentimes it will be you as the grantor or you and a spouse as co-grantors. You have the ability to manage your assets if you're the co-trustees during your lifetime, And you can specify in that document who would manage those assets upon you passing or becoming incapacitated, and whether the assets get distributed at certain times or upon certain conditions. A will is a document that specifies how your assets will be distributed upon your death. So a will only goes into effect essentially once you pass away. So your assets can either be held in your name individually, John Smith individually, or in the name of your trust. So if your assets are held in the name of your trust, then it would be held, like my bank account is titled as the Andrea Daly Revocable Trust. And you can choose to manage and hold the bulk of your assets either in your name personally, or in the name of your trust. And that's true with investment accounts, IRAs, your house, your vehicle. And where something can't list your trust as the holder of the account, your trust can be named as the beneficiary. So for example, if I have a 401k and I list I might list my husband as the beneficiary with my trust being the successor beneficiary, and that would ensure that if my husband dies before me, that my 401k goes into my trust upon my death, which is very convenient. So as you think about how to title your assets, if your assets are named in the trust, then the trust holds those assets prior to your death and upon your death passing, and how those assets are distributed will depend on whatever you decide between you and your lawyer about how you want your assets to be held. If your assets are held jointly, like let's say you're married and you list you and your wife as co-owners of a bank account, or you list yourselves as joint tenants with rights of survivorship on your home, then whatever those assets will pass immediately to your loved one upon your death, if they're held jointly. And in that instance, I always recommend, if you have a trust, that the trust be named as the successor beneficiary. In some instances, assets also pass outside of probate, like an IRA or life insurance. However, for all other assets, if they're not named in a trust, then they're going to be in your personal name, and this would include, your home, your car, your jewelry, your paintings, whatever other possessions you have. And what happens is, if those things are in your individual name, then you're going to have an estate that needs to be probated upon your death. So what I want to explain now is how, very briefly, is how the probate process works. Essentially, what happens is, if you die and you have assets that are in your estate instead of in a trust, then someone is going to have to file your will with the court, the original will. Then the court is going to hold a hearing to determine whether or not that individual should receive the appointment to act on your behalf. Then that person is going to all heirs are notified so that they can participate. And if there's going to be a disagreement as to who should be in charge, then they're going to have to duke that out with the court. Then the court will order a bond to be issued, which is like an insurance policy. And then once the person has that bond and gets their certificate of appointment, they need to do an inventory, which they submit to the court, of all your assets. Then they need to begin to identify debts and collect assets, and then determine the accurate value of all the assets with formal appraisals, and then start to determine how to distribute the assets. So, and in the meantime, there will be annual accountings that the court has to approve. So if you want to avoid complications and delay, then you want to avoid that probate process. That takes time and money. It can take years. And I'll give you an example. My father passed away a couple of years ago. He lived in Massachusetts, but spent time in Florida. He actually had a trust, but he didn't fund his trust. He didn't put his assets in the trust. So we actually had to do a Massachusetts probate and a Florida probate. And the Florida probate alone took a year and probably 3 months, and cost me about $10,000 in legal fees, or cost his estate. So for a lot of people, they want to avoid all that. So if you want to avoid that kind of thing, then you're going to want to do a trust. What if you don't have a will? What happens then? Well, then anybody, a loved one or a neighbor, I mean, anybody is going to have, someone's going to have to file a petition to seek to be appointed as your administrator. And then what will happen is you'll die in a form of what's called intestate, which means without a will. And then what happens is there's a formula, a very rigid formula within the New Hampshire laws that identifies exactly how your assets will pass. So for example, if you have a spouse and children with that spouse, then the spouse gets the first $250,000 from your estate, and then half of what remains, and the rest goes to the kids. If you die with a spouse and children, including children from another relationship, then your spouse only gets the first 100,000 in half, and then the rest is split with the kids. You know, and that kind of formula can be problematic if, for example, you have a long-term partner, but you two didn't get married, then that person's not going to have any protection under the law. Or if you have children who you raised and treated like your own, but did not adopt, those children also will not have any legal rights. So it's best to avoid that process. So the issue of a trust instead of a will, I think that, you know, I've explained why it's important to have it to be revocable instead of irrevocable. It really allows you a lot of flexibility to do whatever you want to do. Some people want to identify a set payment distribution scheme that will take care of their partner and children for a set period of time. Other times, parents want to make sure if they've got a child who has a problem with money, or maybe an addiction issue or a disability issue, that there's money that will be there for an extended period of time to protect that individual. So you get to do any of that however you see fit. And you also get to proceed as the trustee. Whoever takes over as the trustee when you pass away or become incapacitated has the ability to do everything without court oversight. So your trustee can liquidate investment accounts, your trustee can sell the home, can distribute jewelry, get it appraised and then distribute, doesn't have to get approval and distribute accountings unless there's language in the trust that says that accountings are mandatory. And so for many people, it's a much more efficient process. I think that I think one of the really important things to think about, both with regard to a will and a trust, is that if your circumstances change, it's important to go back and look at your documents and consider whether or not you know, your documents need to be changed. And I'll give you some examples. If you have 4 children, and one of those children has demonstrated a real difficulty with money, or maybe that child has stolen from you over an extended period of time, and you've decided that that person shouldn't receive any more assets or should receive substantially less than other people, then you're going to want to go revisit your documents, whether it's a will or a trust, in order to make those amendments in order to reflect your wishes. It's really important that you do that. And I have many other tips I want to give you about things you should be thinking about once you have your estate planning documents in order. But before I do that, I do want to just go back to trusts specifically and clarify something I said before, which was it's very important to fund your trust. And I may have glossed over that too quickly. So let me try to explain what that means. What that means is that if you've gone to an attorney and you've created a trust document, but you have not retitled your assets to be in the name of your trust, then that trust is of no good to you whatsoever, especially unless you have a will that actually pours things over into your trust. And I mentioned my father as an example. He had this great trust document, but he didn't actually have the assets titled into his trust. So what you want to do now, while you are young and capable, or younger and capable of making changes, is you want to try to take the time to identify your assets and determine how they're titled. And that's something you can talk to your estate planning attorney about, or your financial advisor. And then you want to slowly chip away at filling out the necessary paperwork to identify how it's titled and who the beneficiaries are, to make sure that everything either is in your trust or gets into your trust. I think the analogy I like with regard to funding a trust is it's a little bit like building a house and not taking the time to furnish it. It doesn't do you a whole lot of good unless you take the time to furnish it. I also want to mention with regard to trust that trustees do have fiduciary obligations, as do executors who are appointed by the court based upon what your will says, or administrators who get appointed by the court when you don't have a will. Okay, all of these people have fiduciary obligations. The court system is going to hold the executor or administrator responsible under our probate code, and these checks and balances by having to submit things to the court and give the heirs a chance to speak up if they have concerns, is the way all of that's handled if your estate is probated. If your assets are going to be administered through a trust, then the obligations of the trustee and the rights of the beneficiaries are managed through something called the New Hampshire Trust Code. And there are all sorts of checks and balances there as well. For example, that beneficiaries must be notified upon your passing of their status as a beneficiary. You have a duty to, as a trustee, to keep beneficiaries informed of what's going on. Trustees have fiduciary duties to act in the best interest of the beneficiaries, and to exercise what's called a duty of loyalty. And unless it's specifically waived in the trust document, beneficiaries also have a right typically to an annual accounting. So I also want to mention that if you have assets that are held jointly, all types of assets, they do pass to the other owner outside of the probate process and outside of the trust process. And I also mentioned that briefly before, but I want to expand upon that to make sure you all understand this, because this is a common problem in my cases. So if you have a bank account, for example, and you put a daughter on your account to help pay your bills, and you pass away, your daughter becomes the full owner of that account. Even if the account could have $1 million in it, and then the rest of your assets might add up to $1 million. And perhaps in your mind, you're thinking that daughter is going to then distribute that bank account to evenly to the other siblings. And so everything will go equally. Maybe she will and maybe she won't, but legally she's not at all required to, regardless of what you might have asked her to do and regardless of what she assured you she would do. Same thing with vehicles and houses and tangible personal property. So you want to think about all of those issues. And I did want to mention specifically with regard to CCRCs, while I'm thinking of it, that it is important that your trust be revocable if you're interested in going into a CCRC. And typically with the CCRC, there are assets that would be returned to your estate or your trust upon your passing. And it's important, therefore, that if you have a trust, that your trust be listed as the beneficiary, so that your loved ones can avoid having to probate whatever assets get returned. So in the limited time we have left, I wanted to talk briefly about ways to avoid problems down the road among your loved ones, to make sure that your money doesn't go towards an unnecessary legal battle. So how can you do this? Probably one of the most obvious things you can do is make sure you actually understand how your estate plan works. Make sure you have one, And then once you have one, make sure you actually understand how it works and what it means. Because you can think your assets are going a certain way, and that might not be the case, especially if you haven't reviewed the document in a long time and your circumstances have changed. And I'll give you an example. We had an elderly couple who had 5 children. And when the husband was young and had joined the military, they moved from Massachusetts to California. And in California, I think the JAG attorneys prepared very quick, easy 2-page wills for both husband and wife. And what that document said was that their assets would pass to their children upon their death. And which seems relatively straightforward. But the problem is that the assets were going to pass not per stirpes, they were just going to pass to the children. What does that mean? If my assets pass to my children per stirpes, it means that each share, I have 2 children, that each share, each of my children would essentially get half. And if one of my children predeceased me and had children, then that child's share would go to her or his children, meaning my grandchildren. And in this particular situation, what happened is this young couple had prepared their estate plan long before they finished having kids. They went on to have several more children, and 2 of their 5 children predeceased them. And those children who predeceased them had children of their own. So we ended up in a situation where there was a large amount of money. Both parents passed away, and there were 3 adult children and then many grandchildren, and the grandchildren didn't get anything because they didn't stand in their parents' shoes. And those grandchildren were very upset because they felt that that's not what their grandparents would have done. And of course, the grandmother and grandfather had no idea that that's what would have happened. So please go back and look at your documents and make sure that they say what you want them to say. I also, like, as I mentioned before, you should be revisiting your estate planning when you have major life changes. I think if you see someone who's dealing with addiction, you have a child who you're really struggling with, or a challenging situation that comes up, I think you've got to think about how that might impact what will happen upon your death. I have a very good friend who at one point, she and her brother were really, really struggling over how to handle finances for their parents. And based upon that struggle, my friend went back and changed her trust. And instead of leaving her family member as her successor trustee, she changed it to be another person who she felt was more capable of handling things. Another important recommendation is to avoid the need or the desire to treat all of your children the same. It's not unusual for us to have situations where all 3 children are named, for example, as agents under the power of attorney for healthcare or under the durable power of attorney to handle finances. Or you have 2 kids and you don't want to favor one over the other, so you name them as co-executors to handle your estate or co-trustees to handle your trust. Unless you are confident that those children get along and are able to make decisions when they're dealing with a sad and stressful situation, just avoid it. It's okay not to pick everyone and to treat everyone equally. If you feel that one child is typically better at handling finances and financial matters, maybe that person would be the executrix or executor. Maybe that person should be durable power of attorney, whereas maybe there's someone who's more nurturing who would be better equipped to be power of attorney for healthcare. So think about where those needs will be met. And by the way, if you have elderly friends who are named as your agents under your power of attorney or as executor of your estate or trustee of your trust, upon your passing or becoming incapacitated, it's probably time to update that so that you're not left in a situation where someone has to go to court to get appointed on your behalf. I also strongly urge people to avoid making verbal promises about how assets are going to pass, especially if those verbal promises are not consistent with what the documents say. We deal with a lot of fighting among adult children who were promised that they'd get the house upon their parents' passing. They were assured that they'd get all the jewelry. And when those things aren't in writing and people are going to fight, those things just make the problem worse. If it's really important to you that things get to a certain place, put it in your documents. If you feel that you have children or other loved ones who are capable of identifying things that are important for them to have now while you're healthy, then do that. There are all different ways to do it, but don't put it off, or don't think that making a promise that's not enforceable is going to make the situation better. We also see lots of situations where people leave a second home to a large group of people. Vacation homes, I can't tell you how much problem those cause. Vacation homes where you have six kids or 3 kids who don't get along, and you're going to leave it to them all as co-owners, as tenants in common. It's a recipe for disaster. I'm quite certain that someone's going to end up getting hired, like me, to file a petition to partition to force the property to be sold. Also, be very sensitive to circumstances surrounding second marriages. We see a lot of situations where a husband and wife have kids, then they get divorced, and one or both of the parents remarry. And oftentimes, and I'll just give by way of example, like let's say in this situation, there are 4 kids, the husband remarries, and he puts in his trust document that his second wife is going to be the successor trustee and will receive assets to support her lifestyle during her lifetime, with the understanding that the 4 children will be the beneficiaries upon her passing. And it's not unusual for one of those 4 kids to be named as a co-trustee with the second wife. And I think people mean it as a check and balance, and there's nothing wrong with it. But what we see is upon that first parent dying, who was kind of the glue that may have kept it together, it's not unusual for the kids to behave badly. It's not unusual for the second spouse to behave badly. And the combination of it together, where you've got a clash between, that wife wanting to hold on to the lifestyle she's become accustomed to, and the children wanting to make sure that the assets are preserved in order to get to them, can create a lot of conflict. So you want to be really careful about that, and be confident that your kids and second spouse are going to be able to get along. I also want to make sure that if you have strong feelings about how you want to live out your life when you become incapacitated, that you articulate that in your documents. So if you feel adamantly that you will not ever go to a nursing home, or that it's really important you stay at home until you pass away, and you have the assets to provide that level of support, put it in your documents. There, a lot of times people aren't clear about what they want because people have a hard time talking about these things while they're alive. And then their loved ones have their own strong opinions of what mom or dad would have wanted. And we have many cases that go to court where the children are all convinced that they're right. And we don't know which one's right, but it's clear that they've all been told different things, or they've observed different things about what mom or dad would have wanted. They would never want to go to a nursing home. Of course, they'd be okay being here. So to the extent you have strong wishes about those things, please make sure that you include that information. I also want you to be really sensitive to the idea of making substantial or significant changes to your estate planning documents towards the end of your life, as you get to be older. And the reason for that is because there is a lot of, unfortunately, litigation that can come after you pass. Sometimes it comes before you pass. Challenging the validity of your documents on the grounds of incapacity or undue influence. So what does that mean? Essentially, if substantial changes got made to your documents at a time when you're suffering from decline, let's say that you've got some cognitive decline, but you haven't been formally diagnosed with Alzheimer's, but things appear to be moving in the direction of dementia, okay? And you start making sudden changes where now all of your assets are going to go to one child at the expense of the other two children. It's not unusual for those two children who got cut out to file something with the court challenging the validity of your document. And the two grounds that we as probate litigators tend to rely upon would be you didn't have testamentary capacity. Maybe you were too confused and too far declined to be able to understand what you were doing. And two, and this is kind of a growing field, unfortunately, is the idea of undue influence. And the idea is that if a loved one, typically it's an adult child, sometimes it's a caregiver, but someone who is in a trusting, what's called a confidential relationship with you, meaning that you trust them to handle your finances, to help you with your caregiving needs. If that person is in close proximity to you and is assisting you with regard to getting to the lawyer to amend your documents, and that person is benefiting from those changes, then there can be an argument that's made that that person unduly influenced you to make those changes. And the idea is just that as you're older and if you are frail or sometimes confused, that you are more vulnerable to changes being made. And I can tell you that these cases typically, the litigation can go on for a year or two. It can cost an extraordinary amount of money. And at the center of all of it is typically adult children who are hurt. You know, they're hurt because they didn't understand what happened and wouldn't have ever imagined that their parent would leave them out. It's not to say that you shouldn't make changes if you feel that you need to. And, you know, if you've got people who are behaving badly and acting like they're entitled to your assets, then by all means go about making changes. But it's important to do it thoughtfully and carefully with an attorney and who understands how this might look upon your passing. And I can tell you by way of example that my partners are very thoughtful about doing memorandum to the file of making sure that their discussions with the testator or trustee / grantor are alone without those loved ones around. They make sure that you seem capable of understanding what you're doing and have a rational reason for wanting to do it. And if you're really concerned that someone might want to challenge the validity of your documents, they would probably recommend that you have a language in your document. It's in New Hampshire, it's widely recognized as a valid way of preventing litigation. It's called a no contest clause or interim clause. And that's a clause that essentially says, if anyone challenges the validity of my documents, and this could be in a will or a trust, by the way, if anyone challenges the validity of my estate planning documents, then they will get nothing. And if that individual stands to receive some sort of benefit from your will or your trust upon you passing, then they have to do a cost benefit analysis and really decide whether or not they want to move in the direction of a challenge. If they challenge your documents in court and they lose, then that means they get nothing, which is a big risk many people don't want to take. And if they win, though, then the documents would be set aside. So those are the basics. I could go on, but I think, Jen, are we almost out of time?
Well, we've got about 15 minutes, and I know we have a series of questions.
Okay.
So if you don't mind, I mean, I know you could go on for hours, and it's really incredibly helpful information. So I totally thank you for that. So I'm going to read off some of the questions to you.
Sure.
The first being, how does one amend their current will without using a lawyer? Is it possible? Is there a special form?
Well, I would just recommend not doing it. So every state has a specific process for making sure that a document is valid. And, you know, you want to make sure that there are proper witnesses. You want to make sure that it's what we call self-proving, which means that it has to be notarized with witnesses in the state of New Hampshire. Other states are going to have different requirements, but it shouldn't, you know, you don't have to go and redo everything and spend a lot of money. But I think the money you save by not getting it done by a lawyer is, in my opinion, penny wise and pound foolish. So there aren't forms that I would recommend online, and it's just it's not a smart way to do it.
Okay. Next question, are end-of-life documents or estate documents that were completed in Maine also valid in New Hampshire?
Yes, your documents that come from other states would be valid and recognized here. If the documents are not, like, so if you have a will that's not self-proving, then the lawyer will have to demonstrate to the judge that the will is valid under the state laws from the state it came to, unless everyone can agree to its validity. But it's going to be recognized, and the courts are going to do what they can to honor your wishes if you have documents from another state.
Okay. Next question. If you have a trust and your original trust is in a safe deposit box, both of you pass away, it's a couple asking, you know, what is the best procedure for kids to be able to access the original trust that spells out the plans? They may have a copy, but will the bank automatically allow them access? How does that all work?
Yep, that's a great question. So banks in general and safe deposit boxes specifically will not be opened unless let's say by your children, as an example, unless they're co-owners on the account, or they are named as executors or administrators of your estate. So what I'll give you by way of example, when my parents were both alive and healthy, they put me on to, they opened a safe deposit box in Florida that I didn't even know about. And then they also opened a safe deposit box in Massachusetts, and they added me to that safe deposit box, and they sent me a key. So when they both passed away, I was able to very easily get into the Massachusetts one with the key, because typically you have your key and then the bank has its key, and you both have to go in together to the safe deposit box to open it up. And I was able to go in there without having to go to court and get all sorts of things in order to access my parents' original documents. However, in Florida, I did not have a key. I had to show I had to show an appointment or certificate of appointment from the Massachusetts court. And then I had to have, with my authority, get the bank to have the safe deposit box drilled, because I didn't have a key to get in there. And it was a very specific process. So the more you can do to educate the person who you're going to trust, or share that information with your lawyer, the better.
All right, thank you. Is a TOD account, a TOD account, bypassing probate?
Yes, TOD is transferable upon death. Yes, and accounts that are transferable upon death go immediately to the person who's named.
Excellent. Okay. Does a trust need an executor?
No, a trust needs a trustee. An executor is the individual who is appointed by the court, who's named in your will. So if I have a will and I name John Smith as my executor and he gets appointed, then he will be an executor. If I don't have a will and I die and John Smith goes to court to be appointed, he will be an administrator. But they do the exact same thing. They just have different names. A trust has a trustee, and the trustee has authority before you die or become incapacitated. For most people in your audience, the trustee is the grantor, meaning you who created the trust. And then what you do, hopefully in your document, is identify the people who would be trustee after you if you become incapacitated or pass away. And that allows for the smooth transition and administration of your trust assets without going to court.
I have named a beneficiary on my accounts. Will that take precedence over a trust?
Well, that's hard to say. If your bank account is in the name of the trust, then the trust will dictate how that asset is distributed. If it's a bank account that's outside of your trust and you have a beneficiary named, then that would dictate where those monies go. So if there's an account that's in your trust, but you have a very specific idea of where you want it to go, then you're going to want to articulate that in the trust document to give guidance to the trustee.
Right. How long does probate typically take in New Hampshire?
That is a great question. It's not a fast process, but it's hard to say. COVID really slowed things down. It depends what part of the state you're in. I think that you should anticipate that the probate process will take anywhere from a year to more than 2 or 3 years if there's conflict. If there's no conflict and everyone is on the same page, then the attorneys can do what's called a waiver of a full administration, which means you're essentially signing off on not needing the court to have the administrator or executor jump through as many hoops. So that can speed things up, but courts will want to have hearings and those get scheduled way out. So I would anticipate it taking around a year, if not more.
All right. Next question, is a testamentary will different than a standard will?
No, they're the same document. Some people in their will, they create a trust. And so you can have a testamentary trust, but no, it's a similar name for the same document.
Okay. How do I pass home ownership to my daughter if bank still owns the house? I'm still paying mortgage on it.
Well, ownership, if you don't, how you own your house and whether you own have a mortgage on the house are two separate issues, right? So even though I have a mortgage on my house, it's titled under my name, right? And if I want my home upon the mortgage being paid to go to somebody, then I would want to put that into my trust or my will, unless I'm going to add them to that title now as either a joint tenant with rights or survivorship or a tenant in common. There are different ways of doing it, but it's not unusual to see situations where, let's say you own a home that's worth $500,000 and there's $200,000 owed on the mortgage, where your will or trust says that your daughter has the right to receive that home and can use whatever other monies are available to her in your estate to pay the mortgage. Or otherwise, it could be something like she's going to have to take over the mortgage and then she could keep the home. So you just want to be thinking about those details.
Okay. The Riverwoods refundable entrance fee is held in both spouses' name and not in a trust. Upon the death of the second spouse, the refund can be payable to a trust. Does it go through probate during that process?
No, if you have it payable to a trust, then you bypass the probate process. And that's really important because my partners will tell you they've had lots of situations where the parents did a really thoughtful job of setting up a trust and all the assets were titled in the trust, but they forgot about that refund and there ended up being a probate in order to deal with that asset. So yes, you can void the whole probate process if you name your trust.
And we have an assignment of refund form where you would do so.
Perfect.
Thank you. What happens if after funding the trust, some of those assets included are sold? Does the trust have to be updated periodically?
That's a good question. I think if the assets change, it's a good idea to make sure your estate planning lawyer knows of significant changes. But if the assets have been sold and are no longer in your possession, it's not critical that you update your trust document. I think the important part is if you have one asset going to one child and one asset going to another child, your document may not fairly reflect what you want to happen if you want your children to be treated equally. So you want to make sure that someone's looking at the big picture.
Next question is, each of my financial assets is individually designated as transfer upon death, and my home and property is already transferred on a beneficiary deed filed in county offices. Will probate be needed?
It sounds like no, but they're typically things that people haven't thought of, like vehicles. You know, you could have tangible personal property if you've got a nice painting on the wall, if you've got jewelry that you inherited, if you have antiques. So you want to think about all of those kinds of things as well.
What suggestions do you have for assigning a trustee outside the family, attorney, non-family, etc.? I do not want to assign my husband or my sister or his siblings.
Well, there are attorneys who work in this field and are willing to take on that role. They would want to get paid. But it's, you know, it can be an efficient way of doing things because they understand what the rules are. So, you know, there are, you know, if you, whatever state you're in, if you reach out to your estate planning attorney or attorneys who do estate planning and ask if they'd be willing to take on that responsibility, they often are.
Great. We have a few minutes left. We'll try to get to a couple more questions. Should you put a term life insurance policy in a trust?
Well, I think any life insurance policy you want to make sure that the trust is I think you want to make sure that the trust is the beneficiary unless there's a named beneficiary who's out there. One way or the other. Life insurance passes outside of probate. So if the term comes up and there's money available to go to the beneficiary and there's a beneficiary there, then it will go to that person. If not, if you have the trust listed as a beneficiary, then it will go to the trust and bypass probate.
Thank you. Let's see, who is best to establish the estate plan?
Who is best to establish the estate plan? I'm not sure. Well, I mean, all of you as people who are watching this are the ones who need to determine what's right for you. So I think the important thing is that these are complex concepts, and they can be, right? Like this idea of per stirpes versus assets going outright to the children if they survive you is a concept that you're not going to understand unless you go to law school, which is why I would encourage you to, you know, do some research on your options for estate plans and understand what your assets look like and talk to someone about what you're trying to accomplish, and then they can make recommendations to you.
What happens to assets if one has no family and no trust or will to identify the beneficiaries?
Well, typically there's someone. I mean, it could be a sibling or a cousin. I mean, our statutory scheme goes pretty far out if there isn't an immediate loved one available. It would ultimately go to the state of New Hampshire if, or into taxes, into the federal government if you have a big enough estate and you don't have anyone to give it to.
Okay.
I should mention, I'm sorry to interrupt, Jen, but if you have people in your audience who have assets and don't really have anyone to leave them to, something worth considering is talking to someone like the Charitable Foundation about, you know, things that you could help fund upon your passing if there's something that you're passionate about. So you don't have to just give up and say, I guess it doesn't matter, if there's something that might be of interest.
Carol asks, please discuss the use of transfer on death accounts and whether they can be set up to pour over into a trust.
Yes, transfer upon death, TODs, or payable upon death can be set up either to, I mean, really all you have to do is go to your financial institution and ask if you can designate a beneficiary upon death. And they will have you fill out a form. It can be very easy. A lot of times it's something you can do online, and you can name your trust as the beneficiary upon death. And that's a nice way of making sure things get caught and transferred to your trust. We
have a lot more questions, but I think we should just address one last one out of respect for your time. Please explain your statement that a irrevocable trust, a Medicaid trust, it doesn't work in New Hampshire.
So an irrevocable, there aren't many times that I see an irrevocable trust set up for a purpose other than to try to do Medicaid planning. Most people during their lifetime want to have the control over their trust assets to change how their money is divvied up upon their death. And they want that ability to change it until they die or become incapacitated. So most people want to have a revocable trust so that they have the flexibility for whatever reason. If you get remarried, if a child dies, if you move and you decide to support one child more over another. So most people want to have the flexibility to change. When I see an irrevocable trust, it's typically because the grantor, meaning you, was told by an attorney that if you set up your assets in an irrevocable trust and put someone else in charge, then it can look like you don't have money for purposes of convincing the government that you should be eligible for Medicaid, okay? And typically that doesn't work because typically the grantor still has some control over the assets. So if I have $1 million and I have it in an irrevocable trust, and I name my son as the trustee, and I name my son as the beneficiary. So theoretically, I'm not seeing a penny, but he's really taking the money and giving it to me. I'm not going to be eligible for Medicaid. And if I did all of this within there's a 5-year look back period. The government, before it starts giving money away through Medicaid, is going to look like scrupulously through your assets to see when things were transferred and how they were handled. So in our experience, the Department of Health and Human Services doesn't take a Medicaid trust seriously. And that's the only circumstance I'm familiar with when someone has done an irrevocable trust.
Okay. All right. Excellent. Well, I'm sorry we don't have time for more questions. Your information has been incredible, and we really, really appreciate your time, Andrea. And thank you all, everyone in the audience. Thank you for joining us. If you'd like to learn more about our communities, certainly schedule a tour. You can scan the QR code here or call us. Be happy to show you around. And thank you, Andrea. This has been a wealth of information. We really appreciate it.
My pleasure. Good luck to everybody. Take care.
Thanks a lot. Yep. Bye-bye.